I am appearing for the Paradip Port Trust.
Yes.
Port Authority now called, my lord.
Yes.
Now, my lord, actually, my lord, all through the record, your lordship will find PPT, because, my lord, it used to be called Port Trust. The Paradip Port Trust, my lord, has 14 berths, or maybe 15. They had 14 berths inside the harbour. And, my lord, out of these, my lord, 2 berths were captive. One captive berth, my lord, was by agreement given to Paradip Phosphates Limited, which is the respondent in this matter. The other one was originally given to Oswal, and then subsequently, my lord, it was given to IFCO, which is a public sector organization. PPL, Paradip.
When it was given to the respondent, it was also a public sector.
Yes.
Later on, it was changed.
Yes, that's what I was going to just say, my lord. Paradip Phosphates Limited, when this agreement was entered into in 1985, was a public sector concern, but while the arbitration was going on, it became a private entity on or about 28th of February 2002.
Yes.
Yes. Now, my lord, the agreement is of 1985.
Yes.
The agreement had an annexure, which annexure gave the berthing facilities, the rates to be charged for berthing facilities. And, my lord, your lordship may recollect that there are 2 clauses in this act, in this agreement, which are of relevance to, my lord, the present proceedings. If I may just go back for a minute, my lord, to those 2 clauses, my lord. The first clause, my lord, is clause number 1, which is at page 51. My lord, there are, yes, I should, my lord, point out that there are 2 matters before your lordship. The first one is 9751 of 2023, and the second one is 9870 of 2023. My lord, the facts are interconnected, as your lordship may recollect. One deals with, my lord, the award made by the arbitrator for a particular period, and the other deals with, my lord, the fixation of rates by the
notification.
By the authority.
By notification or something.
No, my lord, yes. My lord, may I just repeat that for a minute, my lord? When the agreement was entered into, the 1963 Act was in place. Under the 1963 Act, all rates, my lord, are to be notified, are, my lord, actually fixed by the board or the trust, port trust, but with approval of the central government. That, my lord, was section 52. After, my lord, 1997, there was an amendment by which a tariff authority was set up to decide on rates.
Yes.
So the second matter, as your lordships may recollect, deals with, my lord, the fixation of rates by the tariff authority after 1997. Now, the first clause, which is of relevance, is at page 51.
Yes.
I'm just reading it once more, my lord. That the said captive berth shall be exclusively provided for use of the Paradip Phosphates Limited, subject to payment of rates mentioned in the schedule of rates annexed to the agreement, and will become payable 1 calendar month after the berthing of the first vessel at this berth. The rates now charged can be suitably enhanced at such intervals as would be mutually agreed upon by the parties from time to time.
Yes.
Now, my lord, the other clause which is of relevance is to be found at page 56, which said at clause 19, page 56, that the Paradip Phosphates shall be subjected to the application of all relevant laws, rules and regulations of the Paradip Port Trust that are for the time being in force or that would be framed and enforced from time to time.
Yes.
Now, my lord, from 1985, when the agreement was entered into, till 1993, the scheduled rates were, my lord, paid by Paradip Phosphates. In 1993, the central government notified a new rate schedule, and this was, my lord, this was the rate which we gave them at that stage. In fact, they started paying those rates. Between 1993 and 2000, there was, my lord, no dispute raised as to the rates. They continued to make payment in accordance with the notified rates.
So these were the rates which they later on disputed.
In 2000, my lord, after, my lord, a small dispute arose with regard to, my lord, a small matter, which is, my lord, 3 letters which I have shown your lordship. I'm not going back on that, my lord, because
They sought for time and then
they sought time. Some waiver they sought.
Interest and all that.
Yes. Those, my lord, if your lordship so pleases, my lord, I can give the page numbers, or will, in any event, my lord, there is already a
At that time, it was a public sector only.
Yes, it was a public sector. In 2000, it was a public sector. So, my lord, at that stage, what they did was they filed a suit claiming a declaration only, not, my lord, refund of money, because then they would have had to pay court fees. They sought a declaration that all this was incorrect. Under clause 1 of the agreement, they had never agreed to this rate. So, therefore, a declaration that the rates was incorrectly charged from them. In that, your lordship has seen in the plaint that they said that we did consult them, but they didn't. That no agreement could be reached, and then after that we started charging them this rate, which they say is unilateral. Now, my lord, this suit, when it was filed, it was, my lord, referred to, my lord, arbitration.
Both the parties agreed.
Both the parties agreed. In fact, because it was a public sector at that point of time,
Yes.
Therefore, my lord, it went before, my lord, the mechanism, the permanent mechanism which was in place at that point of time, permanent machinery for arbitration.
clause was there in the agreement.
Please. So, therefore, my lord, it went before the permanent machinery, and it was, my lord, put before the arbitrator. And also, my lord, a certain dispense up to the period, my lord, that the new act did not come in. This was to be done by the arbitrator. After the new act comes in, for the last year, it was supposed to be done by the tariff authority. This award, my lord, is the subject matter of the first.
Amendment is in 97, the amendment is there.
Yes, this amendment is in 1997. So, therefore, your lordship.
That award was challenged by the writ petition.
Yes, that's right. Correct.
Fixed by the authority, after that is challenged in the writ petition.
Yes, correct.
Award also.
The award also was challenged, but, my lord, it was. In fact, my lord, it has been decided in a writ petition.
That's correct.
It has not gone by way of, my lord,
Naturally, because the
Section 34 proceedings.
petition act would not have applied.
Would not have applied. Yes. To that permanent machinery and all that. Now, my lord, this 93. So, the dispute was between 93 and 2000, of which the last year was, my lord, under the amended act. So, therefore, my lord, that went to the tariff authority. The rest of it was decided by the arbitrator. The arbitration award itself makes that provision. It says that the rest of it is to go to the tariff authority. We are deciding only up to 1999.
The award also said the same.
Yes, award said that. As specifically, the award said so. Now, my lord, what the award? You have to refund the entire amount of money which was to be which had been collected from 93 to 2000 or 99 actually.
All right.
So this award, my lord, is under challenge in these proceedings. And, my lord, I have
The award, did the award discuss about the import of clause 19 vis-a-vis section 52?
no. What it said was it rejected our contention that the section 52 will at all apply, because it said that under this agreement, only by agreement you can fix it. So the schedule was there and you cannot then change it.
Clause 19 was totally ignored.
Clause 19, my lord, was rejected. We had raised this argument, but, my lord, the clause 19.
I want to know, brother wants to know is whether did the learned arbitrator consider this?
My lord, he considered it and rejected it.
Very well. That's correct. That's correct.
Yes. Yes. No, that's all.
Yeah.
Now, my lord, therefore, my lord, that's the subject matter of the challenge here.
The Red Court rejected both the matters by saying that this is not a matter for 226, the sense that arbitrator has gone into and the tariff authority has fixed it technical aspects. Correct?
Yes. So, my lord,
We can simply ignore the Red Court orders. We can only
Red Court, my lord, is very
Yes,
cryptic.
yes.
It's very cryptic. Only a couple of paragraphs deals with the merits of the matter. Now, my lord, as far as the award is concerned, which is the subject matter of the first SLP, 9751,
Yes.
we have, my lord, basically three arguments. And the first argument is this, of course, that once there is a clause, once there is a notified rate, clause 19 prevails over clause 1. In other words, my
You
lord,
say, as per the act, some rates are notified.
yes,
Then mutual consent is not required.
no longer required, because, my lord, the clause 19 says that it shall be subjected to the application of all relevant laws, rules and regulations of the Paradip Port Trust. Now, the relevant law is the Major Port Trust Act, because Paradip Port Trust is a major port.
That is section 52.
That is section 52
Where is
of the 1963 Act.
Where is it? Page?
My lord, the section, yes, yes.
Whether in the rates which have been notified,
Yes.
there is a special chapter clause for this captive berth and all that.
No.
So uniform rate for all berth,
Yes.
where they have made some investment.
They have not
Is there
made,
any-
my lord,
Is
actually,
there any concession to them or not?
no, there is nothing.
There is.
The Act does not make any distinction.
The authority.
The authority, my lord, also does not make a distinction in most of the
Well,
situations.
there are
I'll show
two
you.
things. One is 93 revision.
Yes, yes.
93 revision is for them only or for uniform, maybe for many others?
No, no, no. It is for all others.
93 also.
93 also is for others.
And similarly, the authority also made. Naturally, authority.
Similarly, my lord, the authority, I'll show your lordship that. It's very interesting. The authority was continuing to do it till, my lord, the matter reached them after the High Court referred it to them. And then, my lord, they went back on all their notifications. But I'll come to that, my lord. Kindly keep that aside for the time being. I'm now here on the award. That is the time period between 1993 and 1999. And there, if your lordship wishes to take a look, then, my lord, section 52.
It
I have downloaded something where it is
not there, it's repealed here.
Yes. It has been repealed later on. Every prior sanction of central government to rates and conditions, every scale of rates and every statement of conditions framed by a board.
It's not there in the act.
Unfortunately,
I'm sorry, my lord, your lordship's book also. Yes. Please see page 50 of the 9751.
Page 50. Ah, yes, correct.
Yes. And there, my lord, if your lordship just goes back one step, section 49 is relevant, because section 49 is how the process starts. Scale of rates and statement of conditions for use of property belonging to the board. This is how, my lord. So, first of all, the board may from time to time frame consolidated rates, that is 50, for any combination of services. 51 concessional rates. 52 prior sanction, every scale of rates and every statement of conditions framed by a board under the foregoing provisions of this chapter shall be submitted to the central government for sanction and shall have effect when so sanctioned and published by the board in the official gazette.
93. Separate rate.
This is
76 of the petition, madam?
Yeah, main paper.
Yes.
There is a special part for the Pradeep phosphate only.
76, my lord.
Yes.
3.1.1.
Yes.
Yes.
So these are not the normal rates. For the phosphate, there are separate rates,
Yes, your lordship is right.
right? So this is what we are asking, because he had the captive, he made some investment and all that.
Yes, yes.
So maybe some rates, different rates were given.
Hmm.
So there are special rates for
Special rates. Of course, my lord, your lordship may note that he didn't make the investment.
Oh, that's right.
We built it for him. We built it for him, my lord. But still,
You had built it. Where is
yes,
that?
we built it. We'll show that, my lord, if your lordship.
So he had not made any investment.
He didn't make
At that time, both public sector, so mutual consent.
Yes.
All right.
See,
it was that.
in the suit filed,
Yes.
what was the challenge? The challenge is only from 1993 onwards, or what?
Yes. 1993 onwards.
Yes, yes.
If your lordship pleases,
That was filed by the public sector, and they were the public sector.
yes, it was filed by a public sector against a public sector.
Clause also there in the agreement also.
Now, my lord, if your lordship pleases, my lord, I can go back to the plain. There's one paragraph which your lordships have already seen,
Yes, yes.
where, my lord, they said that we were called in for a discussion. When we didn't agree, they went ahead and unilaterally imposed it on us. That was, my lord, the way they put it. Your lordship had noted it on the last occasion,
That's correct.
that an attempt was made to reach a consensus, but when consensus wasn't reached, it was notified.
Anyway, now your primary argument is based upon 52.
That's right, my lord.
See, and another thing is
Read with clause 19.
19.
Yes,
The clause 19, of course.
yes.
Clause 19, there is the section 52.
That's-
the other thing is accusants, say they now stay estoppel and
Limitation.
Limitation.
And, my lord, there is another
clause
clause.
interconnected now.
Yes.
See.
Limitation may be for a small period, not the entire one.
Well, yes, my lord, your lordship.
They filed in 99, so
Yes.
The
If they filed the suit in 2000,
we can
then 3 years, my lord, yes, your lordship is right.
no, but in the larger question which we are trying to reframe is that
Yes,
when there was a revision which took place
yes,
in the purported exercise of the power conferred under section 52, read with
Yes.
clause 19,
19.
there was no whisper.
That's right, my lord.
So 1993 they accepted it and they paid.
Correct.
It continued up to 1999.
And, my lord, the cause of action, therefore, for the declaration,
Yes, yes.
my lord, your lordship may consider that the repayment aspect may be for 3 years. But the declaration aspect, my lord, the cause of action starts in 93.
that's right, but still continuing.
No, my lord. It has already arisen. It can't go on and on. But otherwise, my lord, the Limitation Act will never work. There are some situations.
Two has been removed from the statute with effect from
No, this is because, my lord,
97, when
1997 there was an amendment.
authority was created.
An authority was created.
So,
That is how, my lord, this particular provision was no longer.
So when for the first time the authority had notified the rates?
The authority, my lord, yes, 2000 during the period that we are concerned with, 2000 it notified rates. It notified rates in 2005. It again notified rates in 2007, and it notified rates in 2011.
Just
Milord, after that, Milord, is not relevant for our case.
just a minute.
Yes.
see, therefore, there are two issues. Only one is with respect to, as we have said on the interpretation of or application of section 52 and the touchstone of clause 19.
Vis-a-vis 19. Yes.
19, and then they include in the issue of limitation. See, they
And one more thing, Milord, section 55.
appropriate estoppel, all those principles will
No,
come.
I don't go there, Milord. I only say, Milord, limitation, because declaration, Milord, is section 58.
Yes.
And the refund, if that is the claim, that, Milord, maybe 3 years, up to 3 years before the.
First is 2000, then second rate.
What about the one fixed by the regulatory tariff regulatory authority? That is within. What is your case on that?
I'm coming to it. 2000, 2005, 2007, and 2011.
Yes.
This is the time frame that we are concerned with.
All right, no.
Yes.
But he had challenged it 2000.
No, Milord. Now this is the point.
Which rates fixed by the authority were challenged by them?
He did not challenge any rate.
Never.
Never. When we gave a notice saying that you're not paying anything, we are revising, you're not paying
You
anything.
are agreeable with the tariff fixed by the authority into.
Yes. In fact, we have now put on record all those notifications, and we are taking a positive ground that the authority could not have fixed the rate and then gone back on it.
On back means?
Because, Milord, here, in the second matter, I'll just, Milord, state one more fact which your Lordship has seen from the list of dates. One aspect of the authority's jurisdiction was what the award said, that after 99 I will not go into it.
Yes.
So now that takes us to 2000 only. That's only a 1 year thing. The second aspect is, because, Milord, the dispute was 93 to 2000.
But it will be from 97 onwards.
Milord,
So in between there was no rate, so what
yes,
will apply?
correct. So therefore, Milord, as far as the award was concerned, the award said I will decide up to 1999.
That's fine.
Ah.
We will take it from 2000 onwards. We are concerned with the tariff
Or
authority. Yes.
even let us assume from 1999, he referred the matter to the authority. Now, the authority may not have generally fixed the tariff in 1999, but in order to carry out this exercise, which the award says it should carry out, it would take it in, it would not go into that exercise.
Authority had fixed the rate after this.
Just one. The authority, my lord, comes in two ways. One is, my lord, it actually fixes rates
Normal for every.
in the normal course for everyone.
Right.
In addition to that, because this award is upheld, so therefore it is also required to fix the rate for the 99, 2000, that 1 year.
Right.
A second aspect comes into the picture later on in 2009, when, my lord, finding that they were not paying rates, but higher charges after the amendment, in excess of what is stated in the schedule, we said that we are now going to terminate your agreement altogether. When we threatened termination, that time they went to court against the termination.
That is the rate petition.
That is the writ petition. And when they went to court for termination, the court said no, that now there is a tariff authority. This dispute can better be resolved by the tariff authority. So now, my lord, because of that, tariff authority is deciding not just 99 to 2000, but it is also deciding from 99 to 2010. The award here, the TAMP's decision, tariff authority's decision, goes up to 2010. That's what.
So therefore, we take it your main contention on that decision of the tariff authority.
Yes.
Is that after the general notification,
Yes.
you may not have the jurisdiction to revise it in a particular case.
Milord, it is my contention that the authority has decided these questions.
Earlier.
Now, where is
When to
earlier?
notification.
Yes, when those notifications came. But they didn't pay. Of course, Miller,
Is there a change?
they continued not to pay except at the rate of the agreement, which is why, Miller, we threatened them with cancellation. Now, at the time of cancellation, when they filed a writ petition, the High Court said that the authority can decide this question also. What will they pay after 2000? And there, my lord, they go into it de novo and fix a special rate for them.
Special. And reason is that only that they have invested or something?
No. That's not the reason. This is a tariff fixation exercise in which, my lord.
What is the reason that they have been given special rates then?
No, so therefore, my lord, the difficulty is this, my lord. Our principal difficulty became, there are 3 dates which I must give your lordship, my lord, as far as this is concerned. When it comes to the tariff authority, my lord, the High Court order referring it to the tariff authority to adjudicate is on 8th of July 2009. After that, my lord, there is a hearing on 9th of December 2009. Then, my lord, after hearing, they publish an order on 29th of November 2010.
Tariff authority.
This is not a tariff order. This is, my lord, an interim order saying that we want you to give us this kind of data. So it discusses, my lord, how it is going to go about. But this is not the final tariff. It says give us more data to us. Then, my lord, we give more data. And the tariff order actually comes on 8th of December 2011. All these dates are in the list of dates also.
8th of
December 2011.
Yes.
The difficulty is, my lord, that it's a very, very complicated tariff determination process.
8th December date is not there in the...
Huh? I'm sorry, my lord, 22nd of November 2011.
22nd November is...
Yes.
Yes.
Starts at page 229.
229. Yes. Yes, page 229. Yes. 229 of the other SLP, my lord. Kindly
Yes.
keep that in mind.
No.
This is the second one.
Yes. Oh, I'm very sorry, my lord. 22nd of November 2011 is the final order of tariff fixation by the authority.
22nd November.
22nd of November. Now,
This is in terms of the High Court order.
this is in terms of the High Court order plus the award. So, my lord, what happens is,
Award also arbitrary.
award is only 1 year. Award says authority will fix it for 1 year.
2000 only.
Yes. High Court says you will fix it for the rest of the period. So up to 2010, this figure is the final tariff order has come on 22nd of November 2011. Now here our grievance is, my lord, we have as to what is wrong with that tariff order. But, my lord, it will be extremely difficult, my lord, to go into all that because there was no hearing given between 29th of November 2010 and 22nd of November 2011. So they asked for more data from us. Then, my lord, they said it's not necessary to hear you. So, my lord, all the points which
How much is the difference in rates otherwise notified by them and in this tariff order?
my lord,
Huge difference or some marginal?
substantial difference, because, my lord, we have this particular figure in mind that in the other captive berth, IFCO, where we were getting about 2 crores?
2 crores. 8 crores they paid. They have paid 119 crore. In that same period, IFCO has paid 193 crore.
Yes. So we have some idea, my lord, of the difference which will happen, because we have always claimed that they should, the same calculation would be there.
But what is the agreement with IFCO?
My lord, there is an agreement with IFCO, my lord, separate agreement.
Separate agreement, yes.
So
There are also similar clause.
we take it, say, what is the difficulty which you might face can be multiplied for us to understand the nuances of they fix it.
My lord, I am myself struggling away.
So it is
What I am
for us to go into the
Yes. What
See,
I am saying is, my
therefore
lord,
we take it primarily your contention
Yes.
unless say anything apparent
Yes.
We can understand, you can tell us.
Yes.
Otherwise, we take it further. That is concerned, you are only seeking an order of remand. Because primarily. Because according
Yes,
to you, you
yes,
are
because-
asked to give the materials, but not to how to explain them.
Correct, my lord.
Yes.
I can give your lordship, my lord, instances of where, my lord, the arguments differ. I can do that. But, my lord, to invite, my lord, a decision on that is very difficult.
Yes.
And, my lord, this is the
They also may
situation.
not have been heard by the authority.
They were also not heard. That's true. We were asked to give in data, and then 1 year later, the tariff is fixed. So there was no hearing between these 2 dates.
At least on the second issue, I think our role is also very limited unless we find something apparent. What extent can we interfere in this?
My lord, nowadays, if I may put it this way, my lord, nowadays your lordship's going to very intricate tariff questions in the electricity matters.
That's correct. But see, no doubt, if it is apparent, we can do it.
Yes.
Otherwise, we can't go into their wisdom because obviously we are novices compared to them.
I bow
If
down.
it is a possible view
My
of.
lord, I bow down because,
Yes.
let me explain why also, my lord, I am agreeing with your lordship.
Yeah.
In the appellate jurisdiction which your lordship exercises in the electricity cases, the statute provides for an appellate power in this court. But, my lord, here it is coming from the writ jurisdiction. So, my lord, there will be some difference. But, my lord, what is happening, my lord, and I respectfully submit that this tariff fixation, my lord, one minute. Yes. बोला चाहिए जो हियरिंग है नहीं किंतु एक्सचेंज ऑफ कॉरेस्पॉन्डेंस देखा तो लाइट है retreat the impugned order.
Now this issue of jurisdiction, if any, or the tariff authority has been raised and answered by it or no?
No, it hasn't. It hasn't.
That review
Well,
of
that-
review part.
What I would respectfully submit is that point may be left open for them to consider it, my lord, on remand.
That we were discussing, but you may ask.
That is if your lordship will not agree with us.
All right. We got it.
Lordship.
That's all right. I think
I can in fact, my lord, illustrate to your lordship what kind of issues arise in this tariff determination, which would have, my lord, benefited from a proper oral hearing.
Because now the problem for you will be
Yes.
now in case we dismiss your the appeal,
Yes.
SLP.
Yes.
Now the others might also undertake the same exercise.
That is precisely.
Now therefore the primary issue to be considered is not the jurisdiction.
And my lord, at a time when others are paying in accordance with published rates, this one particular person has got an advantage. And my lord, this is an advantage which if they are right, will be in perpetuity.
Yes, then the rates can't be revised.
Not only can't the rates be revised, they always have to be treated on this basis. My lord, there is an agreement. Now, let us assume that the agreement is not terminated or can't be terminated. So, like, what's immediate?
And terminating
Not necessary to afford further personal hearing. That's what I want to get. 28 para.
spend my transportation to leave anything repetitive.
Hmm.
We enter the expression, keep petition, private space.
Remember, so it will be open to deciding.
The tariff authority.
My lord, it is under the statute itself. No.
No.
Who are the members?
Do they have any legally trained mind or only the technical experts?
Technical persons.
now the Supreme Court judge or High Court judge.
No, at that time.
At the time, the technical persons.
Only technical.
Technical and other administrative persons.
Yes. Well, the Constitution is in 47A.
We'll have to now get into that about the second period.
Not the 2021, they probably have the 2021.
That's what it was.
Headed by a secretary, my lord.
It was adjudicated on it was both. Different by the court and by the. Okay, we have to see this, how it went to Tampa and also dictate a part of it. But it will go to the current authority.
It is to be given that is what we call.
Let us see what.
By issuing a public notice?
No.
Yes.
In general, yes.
Like electricity and all that, so
Yes,
public
yes.
notice in which.
In general, yes. But not, my lord, in this case, my lord. In this case.
Not in this case.
No,
Otherwise, a general
he's
notice.
saying notification.
Yes.
Tariff, when it is fixed for everybody.
Yes. Usually, my lord, it is done in that.
2010 onwards, when 4 tariffs you have said, all public notices.
Yes,
put in.
that is
Everybody who wants to file objections must have.
that is done, my lord. Those are all now in additional volume, which is the 5th additional document volume. My lord, at that point of time, it was headed by a secretary.
Whatever is there
Now, my lord, it is headed.
is similar as in the Electricity Act.
Yes.
28, it is a high number. Last one. It is 28th April. Number.
मैं देता हूँ. Just 1 minute. I'll give you. The last one is 107280.
How is it?
107280. Yes. If your lordship looks at the index, all the gazette notifications, including the 1993 one, is here.
93 is there is no dispute.
Yes, but 3 is 2000, 4 is 2005, 5 is 2007.
Which page is 2000?
That is there's an index there. Say 2000 is in page 41.
Yes.
Where is the procedure prescribed for this?
Well, the procedure would be in some rules, perhaps, or guidelines.
Guidelines. 79, page 79.
Of this one?
Yes. No, here it is the notifications and the SOR. Scale of.
Very difficult to correlate any page.
I'll do that. This is it.
No, procedure to be followed. Procedure.
Everything is narrated. In detail, it is narrated.
It is not there that they had invited objections and all that. Where it is mentioned. Read from page 41 onward.
No. That was not there because that is a notification final outcome.
So where it is mentioned?
But I said in the affidavit, then I will show the guidelines how it is proceeded.
So let us see the guidelines.
Sure.
2.2. Lord, your lordship may look at 173. Processing of proposal.
Just Mr. Gupta, 1 minute. Just a minute.
Yes. 2? No, which paper book? 9870. That's the problem. Hold on. Yes, my lord. It's in the other paper book, my lord. 9870. Milord, these are the matters which cry out, Milord, for a compilation, a common compilation.
It's all, see, more we hear the scenic lawyers, our job has become much easier. So, see, I personally find we should not be overawed by the files. After we hear you, then we would only find that there are only 2 or 3 contentious issues involved.
Yes, correct. That is correct.
But documents have to be correlated, left, right, that's the.
No, but that also, Milord, at the end of the hearing, it is easy for us to do it, Milord, because by that time, the entire exercise is narrowed down further.
Yes, that's.
Milord, if your Lordship sees, Milord, SLP 9870 and kindly come to 172.
Yes.
Unfortunately, Milord, it is not easy for us to give your Lordship the PDF page. If I give you the PDF page, Milord, it can be accessed immediately. But Milord, because of the format of the SLP, they do not tally. And for the simple reason that there is a ABCD also in it.
That's you are referring to notification, is it?
Yes. Tariff Authority for Major Ports, 172, it starts. Just to give your Lordship.
The notification of 2005.
Yes, that's true, Lord.
Right.
But so if I may show you, Lord.
The amendment is 97.
Please see 2, sub 2, sub 3, sorry.
It's not good.
Right? No, page.
173.
173, Milord. It's a little difficult to read, but it is at page 173. 3.2, processing of proposals. To try and see if 2000 is there. Milord, it's at page 173 of that file, Milord.
Yes.
3.2. Processing of proposals, your Lordship sees?
You give the proposal next.
Yes, the tariff proposal for fixation will be registered as a case and examined by TAMP with a view to promote the greatest participation of the greatest number of interested parties. Copies of tariff proposals will be forwarded to representative bodies of concerned users and major users of that port for their comments to be received within the stipulated time period and etc. So it will go on. I must tell you, Lordship, the fixation is port-wise. Paradip port has its own fixation.
Yes.
Other ports will have different fixations. Though, when doing, this is one authority. So, Milord, the authority has the experience of fixing in other ports. So, Milord, the same principles, Milord, at least they will have access to for each port.
So notice to all who are using that.
That's correct.
We can take it that the procedure compliance is there.
Milord, we should take it that. But as far as this particular determination is concerned, here probably, Milord, they only gave notice to PPT and PPL.
This is the particular one.
This is
That
a particular
is the
exercise.
2000, 2005.
Because this particular exercise is pursuant to a High Court order.
That's correct. Naturally.
Correct.
IFCO rates were fixed in the normal tariff order.
Yes, it is fixed in the normal tariff. So, Milord, 2 questions, if it goes back to them. One is whether they can depart from the general tariff that they have fixed from year to year. And secondly, if so, if they can depart, in that event, how is it to be calculated for this particular captive berth? Now, of course, Milord, all the data is there. Question is, how is that data to be looked into? For instance, Milord, just to give an example, I don't want to, Milord, burden the record here. Just to give an example, there is a common channel which comes into the berthing area. This happens in most ports, Milord. There is a channel from the, let us say, the sea or the main river. In the case of Calcutta, Milord, it is from the main river. There is a channel which comes in to where the berths are. This is a common channel to all the berths. Now, this common channel has to be dredged. If it is not dredged, it will not be possible to use. Now, how is the expenditure incurred in dredging that common channel to be recovered from the different berth owners? This is the question. Now, we said that the common channel should be recovered pro rata from all the berth owners. The tribunal says no, we have already taken care of it in some other rate, some port charges or something or the other. And therefore, we will not allow it here. Now, if I am there, I can point out to them that this is not taken care of in the port charges.
This is not a fixed kind of a thing.
This is not a fixed kind of a thing. And anyway, my lord, your lordship knows that this tariff determination exercise has now become so complicated that there is an elaborate hearing process wherever you look at. In the gas authority, in the electricity, in telecom, everywhere, my lord, there is detailed hearing of multiple parties.
Another case is still pending before TAMP now. After 2020-24, there is another High Court order sent to the...
Another High Court order pertaining to the present party.
Present party, both the parties. And they have filed a case before the TAMP.
No, but they may be challenging the tariff order.
No, they can. Of course they can.
That they can challenge.
When notification was issued, they challenge again, we ask for the...
Normal tariff order of the tariff authority.
See,
That they may have challenged.
there are
They have not challenged.
Who has challenged?
Notification that they have not challenged.
What is this?
They have challenged as in 2009. Whenever we asked them to pay this much of amount because of this clarification notification scale of rates, they went to the High Court. Then we said we will.
when I got said, ask the tariff authority to look into it.
Then again sent to the same process. It is pending before we have to file the response. High Court our
Judgment. 28 of the Indian order. 8.
There is no appellate authority in this otherwise.
No, there is no
Like
appellate.
in electricity, we have.
Yes.
Telecom also we have.
Telecom we have.
And
new act to the Supreme Court.
appellate authority.
Oh my God. It will come back.
Now the composition has changed, is it?
Yes.
Oh, it is headed by whom now?
And now headed by Chief Justice of any High Court.
High Court. Supreme Court.
This is, my lord, when the act itself was repealed, 63 Act was repealed, it was not amended, and it's been replaced by the Major Port Authorities Act of 2021. That's a new act altogether.
Oh, thereafter another act has come, is it?
Yes, yes.
Okay.
So in my lord, 2021, the 1963 Act was no longer amended, it was repealed, and a new act came into force.
This entire exercise, this court will have to do then.
After that, my lord, now another
Appeals come.
Yes.
See, in the lighter vein, Mr. Gupta, I think we have to decentralize. You can't just put everything to the Supreme Court and make it as an appeal now. Even we may not have the expertise to go into all this thing.
My lord, this is the problem of tribunalization.
Yes, that's correct. Yeah,
Because-
you can't make the top heavy.
Yes, because when we went for tribunalization, we gave the entire appellate jurisdiction, my lord, to the Supreme Court. Otherwise, kindly consider, my lord, consumer disputes, not, my lord, the most important disputes. I mean, they are important, but they are not very complicated disputes. They are, my lord, your lordship is an appellate forum.
That is your understanding. Consumer dispute are the most complicated dispute.
No, I take back. I take back that comment.
Because Roy will tell you is this.
Yes.
Every other dispute will come under. If you see, if you
Yes,
go through
quite right.
the definition clause,
Quite right,
all and sundry would come under.
lordship. We were very anxious, my lord, when one category of disputes was sought to be brought under.
Unfortunately, my little experience here is that we are groping in dark and we are proceeding in a wrong direction all the time. I mean, see, you are all expert in this field. See, some thought process should be there. What is ailing the system? How do we move forward?
True.
There is absolutely nothing.
My lord, I may tell your lordship, my lord, how this has evolved also. Just see, my lord, what has happened, my lord, in the environmental field. Initially, my lord, writ petition was all that was possible. So, my lord, the writ jurisdiction is very limited. So, therefore, your lordship suggested, specifically suggested, that there has to be a tribunal. But now that we have a tribunal, it's all landed back.
Absolutely wrong. See, when we don't want to say, when you take the constitutional power and give it to the tribunal, you have to make it as a permanent body and then fill up with and then make it act like a constitutional court. We don't know. Very, very strange. That's what we can say.
In fact, the environmental tribunal is not even a 323.
You trace it up
AB
in the
tribunal.
constitution.
It's a separate act.
It's just a tribunal. It's a regular tribunal under the law, but it has 226 powers. And my lord, it is exercised very widely. My lord, I wanted to show your lordship, my lord. My lord, under the new act,
Yes.
the composition is in section 56, and it is, my lord,
Okay. Yeah. Yes, yes. Yes.
my lord, person shall not be qualified for appointment as presiding officer unless he is a retired judge.
Which provision?
56, my lord. We are now on Major Port Authorities Act of 2021.
It's here. Yes, here. Yes.
So either a retired judge,
Yes.
not necessarily. 56, presiding officer,
Yes.
retired judge of the Supreme Court or retired Chief Justice of the High Court. And members, Chief Secretary of a state government or equivalent, retired Secretary of the Government of India.
In the later vein, with the arbitration work picking up, even we are also lured into the other field. So whenever it's offered now, judges are not willing to go for this post now. So we also tend to think after retirement at least we try to catch up with all of you. Certain way.
Actually, it is a wonderful thing.
Yes.
Actually, it's a wonderful thing.
Okay, we thought you submit up.
I'm more or less, my lord, done.
Yes.
I wanted to show your lordship, my lord, 2 or 3 things.
Yes, please.
If your lordship wishes, my lord, I can take 10 minutes tomorrow. But I want to show your lordship how it has been dealt with in the writ petition, in the impugned judgment. This point, namely that there was no hearing.
Yes.
Just see, my lord, para 28 at page 15. 28.
Second rate.
Yes. This is the 9. No, this is the first writ.
Both were decided together.
Both of them have the same impugned judgment.
Yes.
There it is 50 years in both places.
Paragraph?
15 para 28. Page 15 para 28. Or 27 if your lordship may see. He accordingly submits that there was a denial of personal hearing afforded to PPT before the final order was passed. 28. A perusal of the above paragraph shows that it refers to all the steps that were gone through before arriving at the final determination. As correctly pointed out by TAMP, both parties underwent a process of mutual consultation between them, and minutes drawn up of earlier proceedings reflected both their views, not without a common view, their disparate views. It was in that context I just want to read the next sentence. It was in that context.
We saw that.
We saw that.
It says that no need at all.
Yes. As if, my lord, there was some mutual agreement between the parties. There was none. Both parties, my lord, views were elicited. Then, my lord, they prepared, my lord, a chart showing this is their view, this is our view. And then, my lord, gives the decision. Now, my lord, just to, I can actually, my lord, finish just now in 5 minutes.
No.
What I want to do is to, my lord, just briefly tell your lordship that on the award question, we are taking 3 points. One is, my lord,
We got it.
yes,
The
clause
limitation-
19,
Yes,
Yes.
1952.
yes. And, my lord, second point is limitation. And the third point, my lord, just so that your lordship may recollect, I have already said this.
55.
There is a section 55.
55, we don't know.
months.
Yeah. 6 months you have to, if you want a refund, you have to tell. Now that, my lord, is a clear case of, my lord, going past the legal provisions. And your lordships have said, even in the context of section 34 of the Arbitration Act, we are not here dealing with a section 34 application. But your lordships have said, even in the context of section 34, that if the law is not followed and if the contractual clauses are not properly,
55 might apply. All right, we'll consider.
whatever,
Yes.
I leave it to you. So that is, my lord, as far as the award is concerned, and as far as this is concerned, my lord, I have, my lord, made my submission that,
We got it.
yes, lordship.
We'll come back to you in a second.
My lord, if your lordship, please, 1 minute. My lord, the last judgment, or one of the last judgments, on the question of, my lord, arbitration, award, how your lordships will look into it. The last judgment is a very recent one, my lord. 1 minute. My lord, OPG Power Generators versus Enexio 2025 to SCC find that there is an elaborate discussion and summarization of the entire law on the subject in paragraphs 55 to 84. I know, my lord. Quite a summary. But, my lord, it is very useful, my lord, because we find it all in one place and we don't need to keep citing other judgments.
Arbitration is something which is expected to be very simple. But in our own way, we make it complicated all the time. So, very well. All right, sir. We'll come back to you then
Lordship,
tomorrow.
very good.
We'll start by 2 o'clock.
Plus, may I mention item 45, plus it was taken up at 2 o'clock and your lordship will adjourn it to next week. I've just, one, item 45, plus my apologies, I was just outside, plus in the matter
What
was,
is it?
item 45 has been kept next,
45.
45.
Yeah, we adjourned it. We'll let it come.
My apologies.